Hi, and welcome to an introduction to 18 USC Section 209 and 5 CFR Section 2635-503. This presentation is meant to be an overview for newer ethics officials and for those who want a brief refresh. I'm Morse Barron, an assistant counsel in OGE's Ethics Law and Policy branch. To provide a roadmap, today's presentation will be broken into mainly two parts. First, I'll discuss Section 209 with an examination of the elements that constitute a violation of this statute. Then, I'll take a similar approach in discussing 5 CFR Section 2635-503. I said mainly two parts because at the end, I'll share a hypothetical exercise that I'll go over in more detail in a future presentation to give you a sense of how both of these provisions operate in practice. Now that we have a roadmap, let's get started. Next slide, please. As I mentioned, we're going to begin by looking at Section 209 and its prohibition on supplementation of salary. Next slide, please. So, what does Section 209 actually prohibit? What I'll do first is I'll give you a few seconds to read it before we discuss. Okay. In short, 18 USC Section 209 prohibits an employee from being paid by someone other than the United States for doing their official government duties. And let's look closer. We can see that there is a payee offense and a payor offense, which is described in reference to the payee offense. Before we get into the elements, why do we have 209? Historically, there became a concern that a government employee could have a divided loyalty between the government and a non-government entity supplementing an employee's salary. And even if no actual divided loyalty existed, there could still be an appearance of such a divided loyalty. Next slide, please. What elements need to be present for a 209 violation to exist? First, we need an officer or employee of the executive branch. Next, we need this officer or employee to be from receiving a contribution to or supplementation of salary. 3, the salary or contribution to salary must be as compensation for services as an employee of the United States. And 4th, this contribution or salary must come from any source other than the United States. Next slide, please. Okay, for the first element, the recipient of the payment must be an officer or employee of the executive branch. In Crandon v. United States, the United States Supreme Court held that a severance payment made before the petitioners entered government service was outside the scope of Section 209 because employment status is an element of the statute. Therefore, the recipient must be an employee at the time that the payment or payments in question are made. Also, officers and employees of government-owned corporations are also considered to be executive branch employees for purposes of 209. And some examples of these entities are Amtrak, Export-Import Bank, and Federal Deposit Insurance Corporation. But what about individuals that have been appointed to a government position but have not begun service? In a May 2002 opinion, the Department of Justice's Office of Legal Counsel determined that the criminal conflict of interest laws apply to appointees when the appointee begins the duties of his or her office. This OLC opinion was then discussed by OGE in Informal Advisory Opinion 02X3. Next slide, please. The second element requires the presence of salary or any contribution or supplementation of the recipient's government salary, which courts have said can be anything of monetary value, whether in the form of cash or in-kind payments. And the payments can be periodic or one lump sum for this element. Next slide, please. Okay, for the third element, the compensation must be for the individual's service as a government employee. Although not found explicitly in the language of the statute itself, the D.C. Circuit held in United States v. Project on Government Oversight that intent is a necessary element of the statute. So, there must be a direct linkage between the thing of value paid and the official services rendered by the employee. For example, in OGE Informal Advisory Opinion 81-X31, OGE determined that the receipt of a bequest by agency employees in a former agency patron's will did not violate 209 because there was no direct linkage between the bequest and the services rendered by the employees of the agency. Next slide, please. And for the fourth element, the source or payer must be someone outside the federal government. And source means any person or organization. The statute also only looks at the direct source of the payment. So even if the funds could be traced back to a source outside of the federal government, there will be no 209 violation if the government is the one actually paying the recipient. An example of this principle is the payment of royalties under the Federal Technology Transfer Act. Under the Act, the government is required by law to pay an employee a certain percentage of royalties that the agency receives from any licensing agreement for an invention that was created by one of their employees. Because the payments are received by the government and then paid by the government to the employee, there is no 209 violation. Next slide, please. So, as an ethics official, what can you look out for? One common scenario that would suggest a violation of 18 U.S.C. Section 209 is where you have a payment to a government employee from someone who has business before the employee's agency, and the payment was not made as part of some established policy. Next slide, please. As you can see from this slide, there are numerous exceptions to Section 209's general prohibition. Though I won't go into detail on these today, I will point out a couple. In A, you'll see that payments from state and local governments have an exception. And in C, special government employees and uncompensated employees also have an exception, or fall under an exception. Should the facts suggest that an exception might be applicable and you have questions, I encourage you to reach out to your desk officer. Next slide, please. Now, what resources are available to you on 209? OGE's most thorough guidance on Section 209 remain Deogram DO02-16. Another resource is OGE's annual prosecution surveys, which typically include several cases involving violations of Section 209. You can also review the Department of Justice OLC opinions for additional assistance, and the court cases I mentioned as well. Finally, your desk officers are always available to answer questions as they arise. Now, before we move on to 503, I want to point out that you must make a determination of whether you think there is a real potential for a 209 violation based on a totality of the circumstances. However, you are not determining whether you think 209 will be violated, but only whether there is a real possibility. And if there is, as a provider of perspective and prudent guidance, you must direct the employee to reject the payment. Next slide, please. Now, let's move to 503. The big difference between 209 and 503 has to do with when a thing of value, a payment, is received. If a payment is received before government service, 18 U.S.C. 209 does not apply. But we have a regulatory provision at 5 CFR 2635-503. Next slide, please. But first, why do we have this regulatory provision? Well, this is what OGE said in the preamble to the proposed rule. And I'll read. An extraordinary payment from a former employer received prior to beginning federal service raises a legitimate concern, and thus an appearance, that the employee may not act impartially in particular matters to which the former employer is a party or represents a party. The disqualification requirement that will be imposed by 2635-503 is intended to address those appearance issues. Next slide, please. Before we get into the prohibition itself, let's examine who is covered by the prohibition. You can see the three elements that you must meet for the prohibition to apply. The first, 503 applies only to payments received prior to government employment. This is prior to the individual beginning the duties of the position, which may sound familiar from our discussion on 209. Now the three elements. First, and likely the easiest in your analysis, is that the individual must have received a thing of value worth more than $10,000. Next, the thing of value must be given on the basis of a determination made after it became known that the individual was considering or had accepted a federal position. If a former employer determined it would give a payment to an employee, and it was determined prior to the government employee being considered for government employment, or if the former employer decided to give the payment and didn't know the individual was seeking a government position, 503 does not apply. I will also note that former employer is broadly construed to include any person with which the employee served as an officer, director, trustee, general partner, agent, attorney, consultant, employee, and even contractor. Now, the third element is likely the most complicated, so let's look at that in more detail. Next slide, please. The big thing to remember with this last element is determining whether the program is established. If the program is established, the prohibition in 2635-503 generally does not apply. OGE explained that a program is established if it meets one of the following. If it is in writing, which can be a corporation's bylaws, a contract, or other written form. Or if there is a history of similar payments made to others not entering government. Now that we understand when an employee is subject to the prohibition in 503, let's take a look at that prohibition itself. Next slide, please. So this is actually pretty simple. The employee may not participate in a specific party matter if the former employer is a party or represents a party. And the prohibition runs for 2 years from the date the payment is received. This is different from paragraph 2 of the Ethics Pledge in Executive Order 13989, which runs for 2 years from the employee's date of appointment, just as a note. Next slide, please. Before we wrap up 503, there is authority for the head of an agency to waive 503 if he or she finds that the amount of the payment was not so substantial as to cause a reasonable person to question the employee's ability to act impartially. If you have any questions on this or any other part of 503, I encourage you to reach out to your desk officer. Next slide, please. Now that we have gone over the elements of 209 and 503, as I mentioned in the beginning, this is a hypothetical that I will examine in another presentation soon to show how 209 and 503 operate in practice. I'll read it. An individual is soon entering government service, and her current employer has a policy of giving severance payments to departing employees, with these payments being based on a formula that factors in the years the employee spent with the company and the compensation the employee received in her final year with the company. The company will pay severance to an employee who goes on to work for the federal government. The employee is going to work for the Department of Homeland Security, and the approximate value of the payment is $60,000. The current employer, a DHS contractor, knows that the individual intends to work for the executive branch, but does not know in which department or agency. So I wanted to share this in case you wanted to analyze it yourself ahead of my future presentation. Next slide, please. I'd like to say thank you for watching, and I hope this has been helpful. If you have questions when you are addressing a 209 or 503 question, please feel free to contact your desk officer, who will be happy to help. Again,